I wanted to just start by giving some references to the evidence on the questions of the connections and characteristics of the defendants, which was raised before the adjournment. First of all, in relation to the centrality of the first and second defendants, if I could draw your Lordship's attention to the second witness statement of Mr. Holland, which is in Core Supplementary Bundle 8, and the relevant page is 142, paragraphs 52 to 55. So 142.52 deals with the location of the Dyson Group senior management in the UK. Exhibits a table of the executive and senior operational Dyson Group staff based in the UK, and then who is here, and there's a list of the personnel. And then 53, I further note, while the Dyson Group moved its headquarters to Singapore, it retained at least 3,500 employees in the UK, including most of the senior management team. And then 54, with reference to the live proceedings, UK defendants' defence of the claims, and reference in 54.1 to Mr. Martin Bowen, the Chief Legal Officer of the Dyson Group. And then 54.2, the 17 additional solicitors identified as working for Dyson Technology.
Sorry, I must be on the wrong page.
I'm so sorry, my lord. 142 of Core Supplementary Bundle. Core Supplementary Bundle.
Page
142.
Ah, 142. Sorry.
Does your Lordship have that?
Yeah, now I've got it.
So I was looking at paragraphs 52 through to 55.
Yep.
And just having done 54, 55 is noting that the audits of the various ATA companies conducted by the Dyson Group and the role of the different employees in that. And then if we could turn to the skeleton at first instance, which is in the same bundle at tab 11, at page 385, paragraphs 83 to 84. And this refers back to the statement of Mr. Holland, clear that the UK's defendants' defence is clear to be coordinated and overseen, and again Mr. Bowen, various subparagraphs, and little e, I draw the court's attention to little e. Mr. Bowen wrote to ATA, Industrial and Jacko on behalf of all three defendants, and he resides in England. So that's on the centrality and location of D1 and D2. As far as D3 is concerned, as I mentioned this morning, they were only joined in because D1 and D2 effectively pointed the finger at them, and the information we have is largely limited to what they have provided. My Lords, if I could take you to the particulars of claim, which is in the full bundle, tab 10, page 159. Starting at paragraph 56. And your Lordships will see there that in relation to the so 56 is looking at the defendant's responsibility for promulgating and implementing the policies and standards. And then 57 sets out the case in relation to the first two defendants, or reference to the various standards and policies and mandatory slavery policy. And then turning over to page 163, your Lordships will see Dyson Malaysia, and there the claimants rely on letters sent by solicitors acting for Dyson Technology and Dyson Ltd, saying that they are responsible in different ways. That's 58.1 and 2, and then at 58.3 the additional information comes from published adverts for various sustainability posts at Dyson Malaysia. And so I don't have an answer for your Lordship as to the size of Dyson Malaysia. It's certainly not in the evidence. We believe it's smaller in terms of employee numbers, but we don't have the evidence of a private company, and we don't have any further evidence. As I say, the evidence we've got is largely limited to what we have from the defendants.
So that is it the totality of the evidence you rely on, first of all, for the submission that D1 and D2 are the protagonists, and
Yes.
D3 a more minor player,
Yes.
and secondly, for your Cambridgeshire factor, that it would be D1 and D2's legal team who would be conducting the proceedings in Malaysia,
Yes. My lord.
because what you've shown us so far relates only to D1 and D2's defence.
That's right, in terms of the evidence, and that was the position I think at first instance. I think then the skeleton arguments have referred to it being the conduct of the defendant's defence overall, and we haven't had any pushback, as it were, from Mr. Gibson, but we don't have evidence to support that. So, my lords, if I could move then to ground 1B, and if I could start just by looking at the claim in the case, so back to the particulars of claim, core bundle 10-135. And I think the relevant passage starts from 149. And this is the basis for our claim, it's based on the policies and mandatory standards which have been created and promulgated, we say, by the defendant. And we cite in the paragraphs from 30 to 55 the various codes of conduct, the Dyson Code of Conduct, and the Modern Slavery Statement. We note that, and draw the court's attention to the fact that in 32, when we're referring to the Code of Conduct, the quote from it says that where the obligations of the Code of Conduct are more rigorous, they will prevail over the relevant national laws. And your Lordship will see there's detail, page 150, about working hours and wages, health and safety, worker accommodation. And, my Lord, picking it up at paragraph 44, it's clear from these various policies and statements that they're intended to apply worldwide, not just in Malaysia. They are created and promulgated in England, but they apply in all the areas of Dyson's supply chain, including, as we see there, Malaysia, China, and the Philippines. And we say that the critical point for assessing the connection of this claim to England is that on the information we have, almost certainly these policies were created and promulgated in England. The policies largely bear the name of Dyson Technology Ltd, so D1, and the evidence that is before the court is that they are highly likely to have been created here. We don't know for definite. But on that basis, we say that the acts and the omissions which give rise to a duty of care arose in England. And it's not that the claim against D1 and D2 is pleaded on the basis that it's somehow contingent or secondary to the claim against D3. It's a direct claim against D1 and D2 on the basis of their own liability directly to the claimants. And
when you say the omissions took place here, one's looking at breach of the alleged duty.
absolutely. So we say the duty of care arose here, but also the breach arose here because...
The breach being failure to take steps to prevent the abusive conduct taking place.
Absolutely, my lord, and failure to ensure that the policies were complied with. The policies are obviously positive acts that are and conduct being sent out to the supply chain.
But the failure to supervise and enforce them, with the consequences that took place for these claimants in Malaysia, sounds rather more like a failure in Malaysia, doesn't it? It's a failure to take steps.
well, my lord, in terms of the decision making and the active steps that the defendant would be taking, we say that would be in England, certainly the creation of the policies, but also the decision as to the extent to which they are enforced and what steps are taken by the English defendants are, we say, we have to look at the employees of the defendant, the physical location of those employees, and there are, on the evidence, the employees are in England, and it's those employees who we say would be breaching the duty on behalf of the defendants by their acts and omissions in England. And I think I took your lordships slightly out of sequence this morning to Mr. Holland's first statement, paragraph 75 and paragraph 116, but I do note them again there. And we say that the judge's approach to this important connecting factor, the location of the tort, particularly the location of the duty of care and the breach of duty, is flawed. My lords will have seen from his judgment that the focus is on the place of the harm and the place of the underlying events in Malaysia. That we say, particularly in the context of this case and this claim, that the key elements are in England. My lord, we say more broadly that his, we look at paragraphs 103 and 104 in a moment, but more broadly that his approach to the connecting factors in the cross-border tort claim is just wrong in principle. I mean, obviously, if you have a road traffic accident, it's easy because all the components of the tort are in one location. But with cross-border torts, there will be different elements in different locations, whether it's professional negligence or conspiracy or any of those other torts. And we say that all the relevant constituent parts of the tort are relevant connecting factors. And I took your lordships to the gateway, the tort gateway this morning deliberately, because it highlights both as a ground for jurisdiction damage, but also the acts which result in damage. And we say that if that's sufficient to act as a ground for jurisdiction in relation to a foreign defendant, it is certainly a connecting factor that the court should be taking into account in the forum conveniens assessment. It constitutes a link between, an additional link to the fact that the defendant is based and is present in the jurisdiction, the fact that the relevant acts are in the jurisdiction, and we say the acts which give rise to the breach of duty, but to the duty of care, but also the breach of duty in England.
Do you say that overall points to England, or just that it's more neutral than the way that the judge?
No, we say overall. We say that combined, if you combine his the flaw in ground 1A, so failing to take into account the very significant connection that D1 and D2 have in this country by virtue of their presence.
No, I wasn't asking you to say that, because we're on location of duty and location of breach at the moment.
Absolutely, but
what do you say if you take those together independently, they point to England?
The location of duty and breach, yes, we do. We say each of those.
I don't just mean for D1 and D2, I mean for the case as a whole. You've got location of duty and breach for D1 and D2 in partly in England,
yes,
but partly completed by the acts of abuse in Malaysia.
Absolutely.
And for D3, wholly in Malaysia, both breach.
No, we say in relation to D3, I was going to come to D3, but in relation to D3, we say there is the limited materials suggest that Dyson Malaysia do work closely with the UK defendants. I'll take your lordships to that section of Mr. Holland's witness statement. It's in core supplementary bundle at tab 2, page 52. Paragraph 117. So he's dealing here with, because it's permission serve out, sort of full and frank disclosure. and looking at the potential argument that Dyson Malaysia has no connection with England. It says it's correct, Dyson Malaysia is a Malaysian entity whose principal base of business in Malaysia. The claimants do not accept, however, it has no connection with England. Materials available suggest that Dyson Malaysia works closely with the UK defendants in the performance of supply chain monitoring and enforcement. It's apparent from the fact that they are extensively involved in auditing the compliance of Dyson Group. Furthermore, the Dyson Group website contains adverts for various sustainability management jobs at Dyson Malaysia with job descriptions very similar to the vacancies advertised at the UK office. This suggests that employees of Dyson Malaysia with responsibility for promulgation and enforcement are likely to work closely with their counterparts. So we say that it's not that there's no connection, but there is that connection, that they are working closely with the defendants in England. My Lord, I was going to come to the judgment and then to look just at what the defendants say the issues in the case, or the focus of the defendants' correspondence on the issues in the case. But the judgment at 103 and 104 is the key part of the judgment on this. I should start with 102, the issues in this case. The judge says the issues in this case took place in both England and Malaysia, however the place where the harm occurred was in Malaysia, and the underlying alleged mistreatment took place in Malaysia. In my judgment, the centre of the gravity of the case is plainly Malaysia. This is a strong factor being pointing towards Malaysia. And then at 103, he looks again at the claim against the Dyson defendants are contingent on the underlying mistreatment, irrespective of whether, in principle, they could be liable. And in other words, even though D1 and D2 are situated in England, the policies which they promulgate apply to activities that took place in Malaysia. The Dyson defendants have not admitted that mistreatment. I cannot assume they will. And then 104, the allegations as the underlying mistreatment are fundamental to the claimant's claim. Well, absolutely, we accept, of course, that the underlying mistreatment is a necessary constituent of the cause of action. But in our submission, there are other constituents which are at least equally necessary. And indeed, they are logically, in some ways, prior to mistreatment. The question of the duty of care and the breach of duty come before, or at least in part come before, looking at the ultimate treatment. And we say that the creation and promulgation of the policies here, which is what we ultimately say caused the claimant's harm, they're both, it's fundamental to the claim that we establish a duty, obviously, and breach of that duty, and any claim is contingent on those being established. So to say that the claims continued on the underlying mistreatment is of course true, but it doesn't take away from the fact that the claim is also contingent on establishing a duty of care and a breach of duty by, we say, the dominant or the principal defendant, D1 and D2, in relation to their activities in England. In those circumstances, we say the underlying mistreatment, although obviously essential, cannot eclipse those dominant issues, without which there could be no claim. And the judge's treatment effectively dismisses the location of those dominant issues as being irrelevant because the underlying treatment is a necessary element of the claim. And as a result, we say he fails to take them into account at all. He says, even though D1 and D2 are situated in England, whilst it is correct that the alleged actions or omissions took place in England, any claim is contingent. Well, that's not an answer to the fact that they are important connecting factors in their own right. It's not a case where it's a tort in one jurisdiction where everything has happened in one place. The defendant's position, obviously we don't have a defence or even a draft defence in this case. We have their position set out in correspondence. And if I could just give your lordships the references to that. Supplemental bundle 2, tab 28. I just want to direct your lordships to two letters. Page 552 of the supplemental bundle.
552.
552. And just to make the point shortly, that the focus of the correspondence is on, from the UK defendants, is that they have no nexus to the matters described in the subject of the claim, so that we wouldn't be able to establish a duty of care or breach of duty. That is the focus of the correspondence. And I draw your lordship's attention to paragraph 2, did not have a cause of action against the UK entities. 3, speculatively asserts a nexus. 3b, the Dyson entities have no responsibility. C is hopeless. 5, just in passing, that on the underlying allegations that the contract with ATA was ended after the investigations in the light of Mr. Hall's complaints, and then they deal then with jurisdiction and then causes of action over the page 555, causes of action against the UK entities, and this is all about duty of care. And the same goes for the letter of the 8th of April, my lord, which is at page 568, particularly 571 of the bundle, SSB volume 2, tab 30, page 568 at paragraph 17 on 571. So it's common ground, that's a key issue, the duty of care, not surprisingly, and that appears clearly in the skeleton arguments at first instance. They raise novel points of law. And we submit, although obviously this is not common ground, that it's unlikely that there'll be a serious challenge to the allegations of mistreatment.
You rely, I think, in particular what's said in the middle of paragraph 5 on 553, if I've understood it.
I'm so sorry, my lord, I've turned it away. 553.
The first time that any evidence was found to substantiate
Exactly.
any of the allegations Mr. Hall had raised,
Yes,
which accepts that at least in relation to some of the allegations,
absolutely, my lord.
there was evidence to substantiate.
Absolutely. And just, I'm very conscious of time, so I need to move on, my lords, to ground 1C, the applicable law. My lords, ground 1C, applicable law. We say the judge's approach overall to applicable law was wrong in principle. His overall conclusion at 122 refers to the fact that there's good policy reasons for letting the Malaysian judges consider novel points of law. We say he's wrong to base his decision on policy reasons. We looked very briefly in passing at the passage from Lord Bingham in Love, and that's cited in our skeleton argument. The doctrine of foreign convenience leaves no room for considerations of public interest or public policy. The other errors in his analysis, we say, include his approaches to the differences he identifies between Malaysian and English law and his approach to novel issues. And overall, his analysis does not reflect the correct approach to foreign law, either in the foreign convenience evaluation or in the treatment of foreign law by the English courts generally. My lords, as your lordships will know, English courts and many English judges are very experienced and used to applying for foreign law. The important context for this is that, 2 points, English law adopts an almost entirely pragmatic approach to foreign law. It's treated as fact, it's not treated as law, and that underpins the court's approach to foreign law and resolving questions of foreign law. And traditionally that's been by reference to expert evidence, although following the dicta of Lord Legate in Brownlee, there's been some relaxation of that, and it's now possible to put material on foreign law before the court without evidence. The Supreme Court in Brownlee gave a ringing endorsement to the presumption of similarity in the English courts. Second important point is that the English court's approach to foreign law and the role for the English judge to use his legal training varies depending on how foreign the foreign law is. And I do highlight the decision of the Privy Council in Perry and Lopag, Lord Hodge. I take the Lordship to do it very briefly. The Authorities Bundle, tab 3, at 34, volume 3 at tab 34, page 1269 is the relevant part of the report. And I highlight paragraphs 10 to 15. And in this decision, Lord Hodge brings together all the important cases and dicta on the approach of the English court to foreign law. And I highlight particularly for your Lordship's attention paragraphs, so the whole of 10 to 15, but particularly paragraph 12, start of paragraph 12, if the foreign legal system is a common law system which adopts a similar approach to legal reasoning and statutory interpretation to that of English law, the English judge at first instance is entitled and required to bear his or her knowledge of the common law and rules of statutory construction in analysing the foreign law. I highlight also on page 1270, still in paragraph 12, just below B, Lord Hodge is looking at the case of MCC Proceeds and Bishopsgate, the well-known case on foreign law. He says the court, just below B, the court went on to state, not entitled to substitute its own views for the view of the trial judge when there was acceptable evidence to support the judge's finding, unless the English court interprets the statute in accordance with English rules of construction, and there is no evidence that different rules would govern the foreign court's construction or evidence the words would have a special meaning. And I highlight that because the judge refers to the fact that in 101 he has regard to the fact that the underlying labour laws that the claimants complain have been breached are Malaysian statutes, where there is presumably a large corpus of law with which the Malaysian courts are familiar. And we say there's no evidence before the judge about that. And in the circumstances where there's no evidence, the proper approach is to assume that the rules of construction and the law is the same. My Lord, it's not enough for the defendant simply to point to differences. If I can refer, your Lordships are well aware of the way in which foreign law is dealt with in the English courts, but for your note I refer you to the case of the Al-Katia decision of Mr. Justice Bryan on the approach to foreign law in foreign convenience. It's Authority Bundle, Volume 2, Tab 20, page 555. And I particularly highlight, I'm not going to take Lordships through it, but particularly highlight paragraph 67, where Mr. Justice Bryan says it's necessary to analyse rigorously what the true issues actually are, whether they're straightforward or difficult, and what the differences are. The judge identifies two differences, the Malaysian statutes, which I've just mentioned, and a difference in unjust enrichment law as to the burden of proof in relation to unjust enrichment. And the point I want to make about the unjust enrichment aspect is that the defendant's expert, Chief Justice Tun Arifin, relies on a Malaysian case called Dream Property, which is in the Authorities Bundle at Volume 3, Tab 41, 1396. And if your Lordships look, not at the moment, but I hope you'll have time to look, paragraphs 112 to 117, and then 128, and you'll see that in that case the Malaysian court looks at Goff and Jones, looks at all the English cases, High Court and above, to come to their decision. And we say it's all entirely comprehensible by an English court. The English court would have no difficulty applying this if there is such a difference. It's not a relevant difference for the purposes of Lord Mance's test in VTB. He stresses the word relevant difference. He says all other things being equal, it's better for a court to apply its own law, but that's particularly important where there are relevant differences. We say in this case there are no relevant differences. On the novel points, the parties acknowledge that there's novel points of law, but that does not mean that the English court is necessarily less well placed to decide the points. It's not a factor per se. The question is how straightforward or difficult is the point. And I refer to a skeleton argument at paragraph 30, which deals with these points. The English courts frequently decide points of law, particularly well placed to do so when there's no language issues. It's a common law system, judgments are in English and follow the same methodology and principles.
I mean, this all sounds, if I may say so, like me arguing the discretion. I mean, Malaysian law is relevant. Your point of law is that you cannot take into account policy issues. So you say he got that wrong. I don't understand how really the point goes any further than that. Does the application of Malaysian law to duties owed in Malaysia is one of the factors?
Well, there are just 2 points in addition to the policy point we do make. One, that the judge's approach is not correct in terms of the evidential position before the English court. If there isn't, he assumes there's a large corpus of Malaysian law on the statutes. When there isn't, the English court proceeds as though it's the same. And secondly, the point that he makes in paragraph 100 of the judgment, he says that English judges could not assume there would be consistency between experts. Well, that's, in my respectful submission, has a slight air of unreality about it. The whole point of having expert evidence is on disputed questions of foreign law, otherwise you don't need expert evidence. And so to highlight the fact that the English court couldn't assume that they would be the same does suggest that the approach is flawed. And so we say in relation to that, the judge's conclusion that it clearly pointed in favour of Malaysia was wrong for the policy reasons, but also those other reasons, and that it really is a neutral factor in the foreign convenience evaluation. My Lord, just turning quickly to grounds 1D and E. In view of the time, my Lords, I do rely on our skeleton argument on ground 1D and also on our second supplemental note, which addresses the abandonment of the libel proceedings. And in summary, we say that the abandonment of the libel proceedings doesn't change whether the judge got it right or wrong on that point at the time of his judgment, and so that should, the Court of Appeal's review should be carried out based on the evidence that was before the judge. Obviously, the fact that the libel proceedings are not now continuing is a relevant factor for this court to take into account. And we, in the supplemental note, say that although we didn't argue the Cambridgeshire point at first instance because we were in a different scenario, we do rely on the Cambridgeshire point strongly. We say there's been a lot of knowledge built up and documents already made available in proceedings in England which have a very significant overlap to the issues, and that supports England as a forum.
So can I just be clear, because I thought that something you'd said in your supplemental note as your starting point was they'll have to make a fresh evidence application to put the notice of discontinuance in, and that's the first question.
Yes.
I know we're talking loosely about discontinuance having taken effect because that's what we've been told, but if it's a matter of evidence we need to see the notice of discontinuance. But are you resigning from that and saying we do take it into account and we do treat it as a relevant factor.
Well, I'm not resigning from it, my lord, but I'm saying that the reality is it is before the court. I think it is in the they are in the bundles.
It's not in mine, I don't think. I think it's got a placeholder precisely because of this point.
There's certainly a placeholder in the bundles for the we set out in our supplemental note our primary case on this, which is the court should approach this as the judge had to approach it. But we also don't expect the court to
not if I mean, let's say you're right and the judge made a mistake about, for example, the English Defendants, and we think that vitiates his discretion. Then what do we do? Surely we have to re-exercise the discretion. Surely then we have to take into account all the circumstances now.
My lord, yes, we would agree.
So you don't object to the
absolutely
notice of
not.
discontinuance going in on that basis?
No, exactly. And we say that at that stage it's relevant on the Cambridgeshire factor, and that links over to our ground 1E, which is the question about the conduct of the defence. And I took your lordships to the evidence on that at the start of this afternoon on Mr. Bowen and the conduct of the defence and the executives and the employees here. And we say that second aspect is the second point highlighted by Lord Gough in Spiliada when he's talking about the insurers. That's we say by analogy, the point applies in this case to
that's
Mr.
your
Bowen
ground.
and the other.
That's 1E. Yeah.
1E. Yeah.
Yes.
So, my lord, I am going to sit down and hand over now to Mr. Craven to deal with ground 2. Lordships will just give us a moment.
Okay. Well, thank you very much. Now, I've got it right, have I, Mr. Craven? That if you win on ground 1, round 2 is irrelevant.
That's right. Ground 2, my lords, as you will know, concerns the judge's rejection of the claimant's case, that there is a real prospect, a real risk that they'll be unable to obtain substantial justice in Malaysia. For ease of reference, I'm going to refer to that as the access to justice issue. By way of roadmap, I'm going to address you in 4 parts. First, I'm going to very briefly address the applicable legal principles. Second, I'm going to then identify a number of important factual points that are not in dispute before the court. And those are helpful in terms of understanding the context of the issues that are in dispute. Third, I'm going to briefly address the judge's conclusions and the basis and assumptions upon which his conclusion on the access to justice issue was reached. And fourth, the main part of my submissions, I'm going to explain why we submit the judge fell into error. At the outset,
as a matter of law.
As a matter of law, and I'm just going to say, my lord, it's important for me to be clear at the outset that I recognise the judge's decision on the access to justice issue is a matter of judicial evaluation, and it's therefore a matter that an appellate court will typically be slow to interfere with. It's not enough for me to persuade you that the judge could have reached a different decision, or to persuade you that if you were the judge, you may have reached a different decision. I need to show a significant error of principle, or a failure to have regard to a material consideration that he ought to have had regard to, or that he reached a conclusion on the evidence that was just simply not reasonably open to you. And I don't shy away from that challenge, my lord. I'm going to submit to you that this is a paradigm example of a case that passes the threshold for appellate intervention. And it's just worth noting that in the order granting permission to appeal, which you'll find at page 123 of the core bundle, Lady Justice Andrews commented that there is a, quote, substantial question mark over the judge's findings on the access to justice issue, and that it is arguable with a real prospect of success the judge failed to stand back and look at this aspect of the case in a common sense and realistic way. And for the reasons which I'm going to develop, we submit that those comments correctly reflect the strength of ground 2. And it's also notable, we say, that the judge's reasoning on the access to justice issue has already been the subject of some cogent academic criticism. See the articles by Professor Geert van Kalster and Dr. Ekaterina Aristova, which you'll find at tabs 42 and 43 of volume 3 of the authorities bundle. Turning to the legal principles, the relevant legal principles are essentially undisputed. As I say, the claimants had to establish, on the basis of cogent evidence, a real risk that they would be unable to obtain substantial justice in Malaysia. There are just 3 points I want to highlight very briefly in respect of the legal principles. First, the test is one of real risk, not one of probability. See the judgment of Lord Justice Waller in Cherney and Derry Pasca, which the judge cites at paragraph 41 of his judgment. Second, although the claimants bear the burden of establishing, by reference to cogent evidence, that there's a real risk of injustice, as Lord Briggs explained in Vedanta at paragraph 96, cogent evidence does not mean unchallenged evidence. Evidence can be contested by the other side, but nonetheless cogent. And the third point I want to highlight is that some of the authorities suggest that the standard of cogency, what's required in order to constitute cogent evidence, will be higher in cases that involve an attack on the independence and integrity of a foreign legal system. And I just want to be clear, this is not such a case. I do not allege, and the claimants do not allege, that the Malaysian legal system is corrupt, or biased, or lacking in integrity. Our case on the access to justice issue is concerned with the claimant's practical inability, by reason of their extreme and unusual vulnerability and impoverishment, to access justice in Malaysia. Now, just one more point on the law. At the hearing in the High Court, we cited 5 cases, including 2 House of Lords judgments and 1 Supreme Court judgment, in which the English courts have held, in a similar context, that claimants had established a real risk of substantial justice not being available. Those cases are all in the authorities bundle. They're summarised in paragraphs 106 to 117 of our High Court skeleton, which is in the core supplementary bundle, tab 11, page 396 to 399. I don't think it's necessary to ask you to turn them up now, but just by way of overview, in each of those 5 cases, the claimants have brought a negligence claim in respect of personal injuries sustained abroad. So in Connolly, the injuries were sustained in Namibia, Lube, South Africa, Pike, India, AAA, Kenya, Vedanta, Zambia. In each of those cases, the evidence before the court established that the claimants required professional legal representation in order to pursue their claims, and in 4 of the 5 cases, it was established they also needed expert evidence. In each case, the evidence established that legal aid was unavailable in the foreign forum and that the claimants would not be able to obtain representation on a CFA basis in the foreign forum. And in each case, the court concluded that there was therefore a real risk that the claimants could not obtain substantial justice in the foreign forum. Now, I don't for a moment suggest that because the courts reached that conclusion in those 5 cases, the judge was therefore bound by virtue of that alone to reach the same conclusion here. I simply point to those authorities to demonstrate that there is nothing unprecedented, nor indeed particularly unusual, in an English court concluding that there is a real risk of an impoverished claimant being unable, because of their inability to fund legal representation and disbursements required, being unable to obtain justice in the foreign forum. And it's notable that in each of those 5 cases I've referred to, the foreign forum was a common law jurisdiction, just like Malaysia, and in 4 of those 5 cases there was no dispute that the legal system was independent and impartial, again, just like Malaysia. So it's the second part of my submissions. There are 11 factual points in relation to the access to justice issue which are not in dispute between the parties before this court. I'm just going to summarise them. First, there is no dispute that the claimants are very poor individuals from two of the world's poorest countries. At paragraph 72 of the judgment, that's page 97 of the core bundle, the judge noted that the evidence presented to the court was that the claimants are very poor. And that evidence included 4 witness statements from individual claimants, which you will find at tabs 24 to 27 of the supplemental bundle.
As you say, it's not contested.
It's not contested, my lord. It's not contested. Second, it's not contested that there is no dispute that in contrast to claimants, the defendants are immensely wealthy organisations. Paragraph 146 of the judgment, the judge described the defendants as having no real limit to the resources available to them. They don't contest that characterisation.
No.
Nor do they contest the judge's statement that the defendants will prove to be tough and difficult opponents wherever the claims proceed. At paragraph 145 of the judgment, the judge stated, quote, "I have no doubt that the Dyson defendants will prove to be a tough opponent if the claim does proceed to Malaysia." And in the following paragraph, 146, he referred to the fact that the Dyson defendants will prove to be a difficult opponent. Third point of common ground. It's common ground that the claimant's claims raise issues which are legally novel and complex. Defendant's High Court skeleton stated, "These claims are novel in any jurisdiction and legally complex." You'll note that's paragraph 104, core supplementary bundle, page 319. The defendant's expert on Malaysian law, Dato' Ma, described the claims as raising novel and difficult points of law, noting that the law will require careful research into these causes of action, as well as skilled and vigorous advocacy. You'll note Dato' Ma's first report at paragraphs 29 and 72, SSB pages 35 and 46, and this is reflected in the judge's judgment at paragraph 131. The judge refers to the defendant's evidence that the case is a novel and groundbreaking one that would require a significant amount of analysis of the Dyson defendant's documents, policies and witness evidence. Fourth point of common ground, there is no dispute that it's likely that the claimant's claims will require the claimants to adduce expert evidence, and that includes both expert medical evidence in respect to personal injuries and expert forensic accounting evidence. You'll note, see the judgment at paragraphs 62, 136 and 137. Fifth, common ground, in view of the subject matter of the claims, these claims could not be brought in Malaysia in the Labour Court or the Industrial Court, which are effectively the equivalent of employment tribunals. And it's also common ground that in view of the financial value of the claims, these claims could not be brought in the subordinate courts, the lower civil courts. They'd have to be brought in the High Court. Sixth, in light of all that, it's unsurprisingly common ground that in order to pursue their claims in Malaysia, the claimants would need to be able to instruct suitably skilled and resourced Malaysian lawyers to represent them throughout those proceedings. Seventh, in terms of funding those lawyers, there had been a suggestion by the defendants at one point that the claimants might be able to obtain legal aid in Malaysia, but that's not been pursued, and it's accepted now that that would not be possible. And the position is therefore the same in this case as it was in Connolly, Lubay, Ike, Unilever, Vedanta. And there's also no suggestion that the claimants could obtain the necessary representation on a pro bono basis. Eighth, in respect of the possibility of the claimants being represented by Malaysian lawyers acting on a conditional fee agreement basis, it is common ground that a full CFA, i.e. one where the whole of a lawyer's remuneration is contingent on success, is unlawful in Malaysia. And that point is recorded expressly at paragraph 156 of the judgment. There was a dispute before the judge about whether a partial CFA arrangement could ever be lawful. The judge ruled that they could, and we don't challenge that conclusion before this court. But importantly, it was and is common ground that a partial CFA arrangement would be unlawful if if the basic fee, which is the upfront payment that's made at the start of the case and which isn't contingent on success, if that is nominal. A nominal basic fee renders the whole arrangement unlawful. Ninth, it's therefore common ground that in order to pursue the claimant's claims through to trial, any Malaysian lawyer who is representing the claimants would be required to undertake literally thousands of hours of work at the risk of being paid nothing for. You can see this in paragraph 139 of the judgment, page 112 of the core bundle. The judge says this: I agree with the proposition that if the claims proceed in Malaysia, this would involve considerable financial risk for the claimant's legal representatives, who would have to commit thousands of hours of work and be at risk that they would not recover for. 10th point of common ground.
Sorry, which paragraph is that you were quoting?
That's paragraph 139 of the judgment.
Thank you. And that's no payment for those thousands of hours. On the basis of your last point, there would have to be a substantial rather than nominal.
Yes, I should be clear. When he says no payment, he means no payment beyond the basic fee. And on the judge's approach, as I'll come to explain, the judge proceeds on the basis that the claimants could find lawyers who would accept a basic fee of 1,000 ringgit. That's about £160. So the judge is really saying there's a risk that the claimants, lawyers would have to engage in thousands of hours of work.
He said one anyway.
Sorry?
He said there was one anyway.
He said there was one, exactly, and I'll come to Mr. Chandrasekharan shortly.
Yeah.
10th point of common ground, my lords. There's no dispute that pursuing the claims in Malaysia would require the claimants to incur various disbursements. Those include the basic fee to the Malaysian lawyer, which we've just discussed, court fees for issuing the documents, filing the documents, cost of interlocutory applications, such as applications for disclosure, costs of obtaining expert evidence, cost of translators because none of the claimants is fluent in either Malay or English, cost of transcribing evidence, and the costs of practical and technological arrangements for remote hearings. And that brings me to my last of the 11.
Cost of translators, you mean oral translation of oral evidence, not translation of documents?
Well, my lord, it's likely there may be requirement for translation of documents because in terms of taking instructions from my client, it may well be that in order to take meaningful instructions from my clients, a Malaysian lawyer would need to translate certain documents into either Bengali or Nepalese in order to put questions to them about what the document shows, whether the document's accurate. But on any view, there'll certainly need to be translators for the process of any giving of evidence, but also for the process of providing advice to clients, taking instructions, updating them on the progress of the claim, etc., because it can't be done in English or Malay. And so my last of the 11 points is that it's not in dispute that the significant majority of the claimants are based in Nepal and Bangladesh and are unable to travel to attend a trial in Malaysia in person. That point is expressly recorded at paragraph 93 of the judgment, where the judge says this, quote, access to justice in Malaysia would be totally denied to the claimants if a remote hearing could not be permitted, given that they would not, for good reason, whether fear of arrest on return or lack of funds, be able to attend in person. So, my lord, those are my 11 points of common ground. I'm turning now to the judge's reasoning on the access to justice issue. His reasoning on that issue is set out in paragraphs 124 to 171 of the judgment. It's helpful, I think, to begin by looking at the conclusions that he reaches, the overall conclusions at paragraphs 169 to 170. And that's at page 120 of the core bundle. Paragraph 169, the judge says, taking the various arguments made by the claimants under stage 2 individually, then stepping back, looking at them cumulatively along with the arguments made at stage 1, bearing in mind Mr. Herner's admonition that this court needs to get real, it seems to me that there is no real risk that the claimants will not be able to obtain legal representation and necessary NGO funding to pursue their claims in Malaysia. He then goes on to make a point about how they wouldn't necessarily receive the same level of service in Malaysia, but that there is no real risk that they will be unable to source suitably qualified and expert legal representatives to take on their case in Malaysia on a partial contingency basis, with the fees and disbursements funded by a combination of the Dyson defendants through their undertakings, NGOs, and the legal representatives themselves. And in paragraph 170, he then goes on to say, I understand that the claimants, they're not in Malaysia, none of them seems to know any lawyers in Malaysia, but I have to assume if they want to bring a claim, they'll speak to an NGO in Bangladesh or Nepal. That NGO will put them in touch with an NGO in Malaysia, and that Malaysian NGO will then help put them in touch with the lawyer. So, 2 points to highlight here. The judge essentially holds that there's no risk the claimants will be unable to obtain substantial justice in Malaysia because the court can be confident of 2 things. First, suitably qualified Malaysian lawyers would be willing and legally able to represent the claimants on a partial contingency basis. And second, all of the necessary fees and disbursements for the claimants to pursue their claim in Malaysia would be paid by a patchwork combination of payments by the defendants themselves, so essentially funding part of the pursuit of the claims against them, voluntary donations by Malaysian charities, and payments by the claimants' Malaysian lawyers. Now, those conclusions were premised on the judge's acceptance of what he called the defendant's case management model and the defendant's calculations of the likely amount of the various costs that would be incurred. And that model and those calculations are summarised at paragraph 66 to 67, which you will find if you just turn back in the judgment to page 94. You'll see paragraph 66 begins, with respect to disbursements, the Dyson defendants provided the court with the estimated costs of various disbursements and explained who would be expected to fund them. A mixture of NGOs, the relevant lawyers and or the Dyson defendants themselves. They estimate the basic fee as being 1,000 ringgit, which equates to £167. And then at paragraph 167, it says, in total, the Dyson defendants estimate the disbursements as costing 9,165 ringgit, £1,534, of which 2,234 ringgit, £374, are not covered by the undertakings given to them. Only the initial fee and filing fee for the statement of case is expected to be covered by an NGO, and not the claimant's lawyer, along with the basic fee, that is a sum of 1,500 ringgit. And then he says, in total, the amounts not covered by the Dyson defendants would come to just over 1,900 ringgit, equivalent to £328. The Dyson defendants did not rely on the claimants themselves making any contribution. Now, those estimates are set out in a disbursements table produced by the defendants, which you'll find in the core supplementary bundle at tab 13, page 446. So I could just ask the court to kindly turn that up. This is a table that was handed up, I think, on the first day of the hearing by the judge, in which the defendants set out what they say the quantum of the various disbursements is likely to be and who they propose can be expected to fund it. And if you turn to the end of the table, and also page 472 in the bundle, you will see an entry which reads total disbursements, and then the figures 9,165 ringgit, £1,534, and then at the bottom, total disbursements not covered by undertakings by defendants, 2,232, £374. So those are the figures that you see in paragraph 67 of the judgment. But those figures are misleading. They need to be treated with caution, because if you turn back a few pages, turn back, for example, to page 470 in the table, you'll see there's an entry, cost of instructing single joint medical expert, N/A. So there's no figure in the table in respect of what is recognised to be an expense that would need to be incurred. And that's not the only one. If you turn back further page 469. Transcription fees, N/A, no figure. If you then turn back to page 457, again, costs of providing remote evidence, N/A. So the judge has proceeded on the basis of a total estimate of disbursements, which even on the defendant's own case doesn't properly reflect the overall quantum of those disbursements, because it's a total that doesn't include figures for various expenses which it recognises would need to be incurred. But that table also doesn't include other expenses, for example, cost of instructing a forensic accounting expert to deal with the unjust enrichment claims, which the judge recognises is likely to be possible, not in the table. The cost of all of the translation that will need to be undertaken by the claimant's Malaysian lawyer in order to plead out and progress their claims is not in the table. And so...
And did the judge accept this table?
My lord, you can see later on in the judgment, he bases his conclusions, paragraph 148 of the judgment, going back to the core bundle, page 114. You'll see that the judge says this: based on the figures provided by the Dyson Defendants.
We've read it. Yeah.
And then he goes on
He did
again.
accept it.
I'm sorry, my lord?
It does seem to have accepted.
He does, and you'll see he refers here, third and fourth line, a sum of 1,916 ringgit, £328 would need to be found to fill the gaps. See paragraph 67 above. Now, I should be clear, my lord, some of the expenses that are not reflected in the table, in terms of a number, are expenses which the defendants have said they will undertake to cover. So,
Quite an unusual arrangement for the defendants to agree to pay everything to let themselves be sued.
it certainly is,
I
my
suppose
lord.
if it's only a few £1,000s, it's fine. But I mean, you know,
Well, my lord,
you'll make your submissions. But
I will, and that's exactly what I'm going.
litigation like this doesn't cost a few £1,000s, even in Malaysia, without taking judicial notice of it.
Of course,
It's
my
just-
lord, exactly.
It's ridiculous.
My lord, that takes me neatly on to ground
Sorry,
two.
Years.
you were just identifying some of the other expenses which weren't in the table.
Yes.
One was forensic accounting.
Yes, and then another is, I think, is costs of translation. And that's not the cost of translating evidence.
No.
That is in the table, but I think it's costs of translating, all of the costs of translation that a Malaysian lawyer will have to incur.
I mean, was there evidence that you put in about the cost of proceedings in Malaysia?
There was some evidence. There was evidence, and so some of the figures in the table are derived from evidence we put in, and then the defendants have applied their own assumptions. So, for example, costs of translating evidence at a trial.
Was there evidence as to how long this is all going to take
Well, there was, I think,
in Malaysia?
I think I can check, but I think our expert estimated for a trial of liability and quantum, 6 months. Then it was said, well, actually, Malaysia.
A trial for 6 months.
I think that's right. Perhaps we can check that.
Liability and quantum, but we said
But of course, the defendants say, well, you wouldn't have a trial of liability and quantum. We'd have a
Okay,
trial.
but what is it for liability?
I'm sorry, my lord.
What is it going to take for liability?
I'm
in
not sure
Malaysia?
that we had a specific estimate, but I think the court can take judicial notice of the fact that even with test cases, when you're dealing with a novel and legally complex case which raises issues of
And this
unjust
partial CFA has this kind lawyer in court for,
Quite, my lord.
say,
And
2 months.
exactly, a partial CFA involving an upfront payment of £167 for what may be 2,000 hours of work, 3,000 hours of work. We say it's completely unrealistic. I was going to move on to
By himself.
well, the lawyer says I could team up with others, but of course that then gives rise to the question, well, are you going to split this extremely small sum between yourself and another firm of lawyers, so actually you're both receiving £80?
I mean, what troubles me about this ground of appeal is that it's a full-scale attack on the facts.
Well,
I mean, basically you're saying that it's completely unsafe finding.
my lord, we are, but we're zeroing in on really two key strands of the judge's reasoning on the access to justice issue. How are the disbursements going to be paid? And is this arrangement one that's been proposed by defence, one that poses a real risk of injustice or not? And then, realistically, is there a risk, not a probability, but a risk that the claimants won't be able to find a Malaysian lawyer?
I mean, he held there was no risk.
He did, my lord, and I submit he was wrong, and I'm going to explain and show you why that's the case. My lord, and I said at the outset, we submit this is a paradigm example of a case that even allowing for the deference that has to be shown to a first instance judge's evaluation, this is a paradigm example of a case that crosses the threshold.
Your first step is, you can see the figures he's taken, they're too small because they exclude.
That's right, and I should say, in fairness,
items that need to be taken account of, and although the other items are ones which are said to be covered by the undertakings, the judge is broaching it on the basis that the undertakings only apply to the gap that he's identified.
That's right, and my lord, some but not all are covered by the undertakings. The undertaking, there's no undertaking in respect to forensic. If we want to appoint our own forensic accounting expert to help us plead out our cases on unjust enrichment, that's not covered by the undertakings. But some of them are, my lord, yes.
But you also say it's just not a satisfactory arrangement to be dependent on your absolutely sworn enemy to pay for your litigation against them.
My lord, perhaps if I can address you on ground 2A, which is concerned with precisely this point. Paragraph 16 of the judgment is where the judge addresses the issue of undertakings. And he summarises,
Which paragraph?
16, that's page 79, bundle.
16?
Paragraph 16,
yeah.
Page 79 of the core bundle. He summarises the undertakings that the Dyson defendants have provided. And in terms of funding, the relevant undertakings are summarised in Roman numeral 3 and Roman numeral 5. He then, when he deals with his analysis of access to justice, he deals with these first at paragraphs 136 and 137 and 138. 136, it says the Dyson defendants have undertaken to pay for many of the disbursements, including joint expert fees. And then he goes on to talk about how the claimants, how they might approach instructing their own expert. 137, he refers to forensic accounting expert. And then 138, he says this: it seems to me, and this is all premised on his acceptance of the undertakings, it seems to me there is a real risk that it seems to me that there is no real risk that significant, let alone very significant disbursements would need to be paid by the claimants or by those who are funding their disbursements, NGOs or lawyers. And then at 147, he deals with our argument that it was inappropriate for the court to rely on those undertakings. He says this is page 114, I do not consider there is anything improper in this court making its decision in reliance on the undertakings given by the Dyson defendants. The giving of such undertakings is not uncommon in jurisdictional disputes. I also do not consider that there is any conflict of interest here with respect to the question of costs. If an undertaking is given to this court that reasonable costs will be paid, then that will presumably be the benchmark by which the Malaysian courts will only address any dispute that may arise on the question of such costs, whether the undertakings were made to this court or, as Mr. Gibson submitted could be the case, the same undertakings were made to the Malaysian court as well. My Lord, there's at least 4 significant problems with what the judge says in paragraph 147. First, he wrongly thinks that undertakings of this nature are commonplace in jurisdictional disputes. But as we point out at paragraph 42 of our appeal skeleton, contrary to that assumption, the provision of undertakings to fund the costs of pursuing a claim against you is unprecedented. And it's telling that the defendants have not been able to point to any previous case where undertakings of this type have been used to defeat an access to justice argument.
How's it policed?
I'm sorry, my lord?
How is it policed?
Well, quite. My lord's ahead of me there. The second point I was going to address is this question of conflict, then I'll come on to policing. So we say there is, contrary to what the judge thinks, there's a clear and obvious conflict between the defendant's avowed intention to resist the claims as strenuously and vigorously as possible. That's how they put it in correspondence, strenuously and vigorously. And their parallel promise to actively fund aspects of the claimant's pursuit of those same claims. Now, the defendants say in their skeleton, well, that argument is inviting the Court of Appeal to proceed on the basis that we will commit contempt of court. And that's not a proper basis on which for us to proceed. But I don't need to go that far. It's enough for me to point out that the defendants have an obvious and significant incentive to adopt an extremely narrow approach to what costs are necessary and reasonable, because the undertakings are framed by reference to those evaluative concepts, necessary and reasonable. And that incentive is twofold. Partly it's financial. The narrower your approach to what is necessary and reasonable, the lower the overall bill will be to you as the person who's got to pay for that. But it's also obviously tactical. The ability to control the funding of the disbursements which the claimants need to incur in order to pursue their claims can be used as a tool to apply pressure to the claimants, to make it harder for them to effectively pursue their claims, or to delay the trial of those claims. And we say there's a real risk in this case of that happening. And that risk is illustrated by the conduct of the defendants in this case before this court. I'm going to give you 3 examples. The first concerns a refusal to disclose documents which were referred to in the witness statements of the claimants, of the defendants' solicitors. The defendants' solicitors' witness statements made multiple references to contracts between companies in the Dyson Group and the operator and owner of the factory. And these references were used as the basis for arguments about contractual indemnities and how a contribution claim might work. The witness statements even included a schedule which purported to summarise over something like 10 pages the terms of some of these contracts. So we requested inspection of these contracts under CPR 31.14. We made 4 requests and they were refused persistently over 2 months, more than 2 months. And as a result of that, we had to issue an application on the eve of the hearing before the judge for an order compelling the defendants to provide inspection of those. Now, probably the most helpful, the quickest way of summarising the background there is to refer you to our note in support of that application, which is in the supplemental bundle, volume 2, tab 88, page 757. Now, I'm not going to ask the court to read it now, but I would respectfully ask the court to read it at a convenient moment, and in particular, paragraph 4 of that note, which summarises the background, because you will see from that a very revealing picture about the defendant's completely unreasonable refusal to comply with their clear obligations under CPR 31.14. And you'll see that we also highlight that when we eventually were permitted to inspect the documents after making the application, we find that it's clear the defendants have made contradictory statements about their knowledge of the contracts. They've made arguments seeking to justify the refusal to comply with CPR 31.14, which are absurd, and they've generally behaved in an obstructive and disproportionate manner. And you can see, after the hearing before the judge, when we finally got the documents, we filed a further submission addressing the contracts, just for your note, supplementary SSB, volume 1, tab 1, page 6 to 12. And I simply point to this, my lords, as an example of the likely attitude that the claimants will face if these proceedings are litigated in Malaysia. It's not going to be constructive, it's not going to be reasonable, it's not going to be helpful, it's going to be obdurate, obstructive, and aggressive. 2 further quick examples. In addition to refusing to disclose those contractual documents, we also became aware of documents that have been filed in the libel proceedings, which appeared on the face of the application they related to that to be potentially relevant to the jurisdiction dispute. We asked for those to be provided, and again we were repeatedly told, no, you're not having them. And we were told that even after the defendants in the libel proceedings said to us, we said to the defendants in this case, these documents are likely to be relevant to the jurisdiction charge. We weren't provided with them. Just for your note, the relevant correspondence is at tabs 47 to 61 of volume 2 of the SSB, And then the third example, so my last example, is a letter that you'll see at Supplementary SSB, Volume 2, Tab 46, page 662, which is a letter that was sent by Shillings, the libel solicitors, on behalf of the defendants to Lead A.
662, did you say?
662, my lord, yes. Tab 46. And it's a letter sent by Shillings to Lead A on behalf of Dyson Technology Ltd, Dyson Limited, so the English Defendants, about a press release by Lead A, and it makes a not very thinly veiled threat of libel proceedings and disciplinary complaints, regulatory complaints. And so this is not a case where you have undertakings and a defendant can simply say to you, well, of course we're going to act constructively and reasonably in relation to these undertakings. You have clear evidence from these proceedings of the reality that my clients are likely to face.
I mean, you know, some of us have been engaged in litigation for a very large number of years, marked in decades. It's a very unusual situation where you're reliant on your opponent, who is massively wealthy, to finance a claim made by people who are massively impoverished.
Absolutely.
And my question is, what else does the judge say about a conflict of interest?
Nothing.
Nothing.
He says there's no conflict.
Just says
And that is, we say, a serious error of principle.
Because if a defendant who is determined to win its claim, which is no reason why it shouldn't be, defendants are fully entitled to argue their claim with great vigour, passion, strenuousness or whatever. But obviously they're going to put obstacles in the way of the claimant. So did you say that to the judge?
My lord, I think we did. I mean, our position was that this undertaking arrangement is wholly novel.
He says no conflict of interest.
He says no conflict of interest. And importantly, you see at 147, paragraph 147 of the judgment, he seems to think there's no problem in terms of how this would apply practically. He says, if an undertaking is given to this court that reasonable costs will be paid, then presumably that will be the benchmark by which the Malaysian...
But he's missing the point with respect. It's not about the costs. Yeah. It's about the obstacles that will be put in the way in order to put the claimants in a position where they can't get whatever it is to defend whatever they say.
Absolutely.
I mean, this is not litigation where you go to a small claim in the county court and you have 2 hours in front of the district judge, which you can argue yourself if all trades fail. This is massively complex litigation, which is very lengthy, and everybody in this court understands fully how such things operate. And anybody who's got any experience of the courts in Malaysia know they operate very similarly.
Absolutely, my lord. But I mean, there's more problems with this. He assumes the Malaysian court could effectively police compliance with an undertaking given to a foreign court.
Right.
It's not addressed in the evidence, and it's not necessarily a safe assumption.
But I mean, these points were made to the judge.
These points were made to the judge. Yes.
Right. Okay. I mean, you might just give
And
us
it was made. I'm told, my lord, helpfully, that it's actually addressed in our skeleton argument. First instance skeleton, which is in the core supplementary bundle.
Yeah.
At tab 11, page 399. And we refer at page 400, top, the manifest conflict between the defendant's interest in defending the claims and the defendant's suggestion they will constructively facilitate and partially fund the pursuit of those claims.
Is that page 400?
400, at the top of 400, yes, my lord.
That's the core supplementary bundle.
Core supplementary
Not the
bundle.
core bundle.
Not the core bundle.
Or the supplemental supplementary bundle.
That's not the...
I have to say, the nomenclature of these bundles is really unhelpful.
Yes, I'm sorry, my lord.
Could have been supplementary bundle 1 and 2.
Yes,
because it is in my folder.
Thank you.
But you said the defendant, the manifest conflict between the defendant's interest in defending the claims and the defendant's suggestion they'll constructively facilitate and partially fund the pursuit of those claims.
I mean, in a sense, my lord, it's such an obvious point that it almost doesn't need to be spelled out.
No,
The judge simply doesn't engage with it, and then he curiously says, he talks about the Malaysian court addressing any dispute that may arise, and he says whether the undertakings were made to this court or as Mr. Gibson submitted, could be made, the same undertakings were made to the Malaysian court as well. But the point is, if we lose this appeal and the claim has to be brought in Malaysia, there's no reason why the defendants have to go and make some fresh undertaking.
They didn't give an undertaking to give the undertaking to the Malaysian.
No, they didn't.
That's your
And importantly, there's also no provision about costs. If there's disputes about compliance with the undertaking, who's going to foot the bill? It's going to have to be, presumably, the client's Malaysian lawyers who are already operating on a shoestring with a tiny upfront fee, or a benevolent non-governmental organisation. So, my lord, I think you've got my points on.
And is there a privilege problem as well? Suppose we're talking about the costs of the individual claimants making travel arrangements or whatever it may be to give evidence. You have to disclose who it is that you're proposing to call, where they're going to be, all matters
There's all kinds
of that nature, without any undertaking on anybody
There is
else's part.
huge scope for professional difficulty.
Is there any example that anybody has ever been able to find where such an undertaking has previously been accepted by the court?
There's a reference in the defendant's skeleton argument to the aerospatial case, aerospatial, which is in, I think, volume 2 of the authorities bundle. And in that case, that's an anti-suit injunction case. It's not a case about appropriate forum, and the Privy Council was very clear to distinguish between the principles that apply to appropriate forum and the principles that govern anti-suit
It was
injunction.
1987.
It was 1987, and there's not an undertaking to fund costs going forward. There's various undertakings, and they do go beyond the kind of classic undertaking to submit. There's undertakings to cooperate in various ways in respect of ongoing foreign proceedings. But it's not an access to justice case. And importantly, the undertakings there are made to the court that is going to remain seized of the dispute. There's undertakings made to the Brunei court. The Brunei court is going to remain seized of it. So policing it is much simpler. Here, it's going to be very difficult to see how this is policed. I mean, is the English court going to be expected to try and engage in some kind of policing exercise, having relinquished jurisdiction? Going to have to make judgments about what's a reasonable cost for travel to attend, to participate remotely in a trial in Malaysia. It's completely unworkable.
Okay.
That's ground 2A. I should say on ground 2A, that's the undertakings. Ground 2A, we make two further points. One is in respect to the costs that the judge says will have to be incurred by Malaysian lawyers. At paragraph 139, the judge proceeds on the basis that the Malaysian lawyers would potentially need to incur translation costs and forensic accounting costs, because those costs are not covered by the defendant's undertaking. And the problem with this is that, firstly, the judge has actually overlooked the fact that on the defendant's approach, there's other disbursements beyond those two that the defendant suggests the claimant's lawyers should bear. Costs of filing interlocutory applications, obtaining court orders, filing replies, etc. So he's not actually grasped that there are more costs than those that he's identified. But secondly, there's no evidence before the judge that lawyers would be willing, acting on this partial CFA basis with a tiny upfront fee, there's no evidence that they would be willing to fund these kind of substantial costs for translation, forensic accounting, numerous interim applications.
Isn't that what happens in this country under CFAs?
It is, my lord, but we're you know, in a sense, there's a few firms in this country that could bring a case like this on a CFA basis, and Lee Day is one of them. The point is there's no evidence of an equivalent in Malaysia. We're dealing with small firms who are being expected to incur huge costs, potentially, well, only view substantial costs, on the basis of a tiny upfront fee. And so what the court can't simply do is say...
And on the basis of a contingent recovery.
Yeah.
That's the whole point of that.
It is, but what the court can't say is, well, because it happens in England, therefore one can assume that the same thing, there'll be a Lee Day equivalent in Malaysia. The whole point is there's not evidence, we say there's not compelling evidence that that is the case in Malaysia.
I just wondered why there was necessarily a distinction being drawn between disbursements being borne by the lawyers and the costs of their own work being borne by the lawyers.
Well, I think the point is that costs of their own work are, in a sense, disbursements are actually having to pay out cash, whereas costs of their own work are, in a sense, doing the work and then not being paid for it until the end of the case. That's probably the only distinction. And then, so that's for lawyers. And then in respect of NGOs, the judge, as I've shown you, at paragraph 148, he says that a sum of just 1,900 ringgit, 328 pounds, would be needed to cover the gap between what's covered by the defendants' undertakings and the lawyers, and then what's going to be met by NGOs. And our key point is that that gap, even assuming that an NGO would be able potentially to make a small contribution, that gap is premised on the lawyer being willing to represent the claimants for an upfront fee of just 1,000 ringgit. And the NGO then pays just that small sum. But we say that's just not realistic. And actually, any lawyer is going to require a much greater upfront sum than 1,000 ringgit. That's ground 2A. Ground 2B concerns whether or not there was a real risk that the claimants would be unable to find a Malaysian lawyer willing to act on this partial CFA basis for an upfront fee of 1,000 ringgit. And we essentially make two submissions on this. First, the judge was wrong, clearly wrong, to conclude that there is no risk that that arrangement would be unlawful, because we say there's a real risk that the proposed upfront fee would be deemed nominal and therefore unlawful. But secondly, and perhaps more significantly, we say the judge was clearly wrong to find that there was no real risk that the claimants couldn't instruct a lawyer on this basis. And the judge tethers his finding by reference to one lawyer, as my lord, the Master of the Rolls, has identified. We say it's clearly wrong. Turning to the first argument, lawfulness of the proposed fee. As I said at the outset, it's common ground that a partial CFA arrangement would be unlawful if the basic fee to be paid under that arrangement is nominal. And I can ask you to look, please, at the expert report of the defendant's expert, Dato Ma. It's his first expert report, which is at SSB, Volume 1, Tab 5, page 44. And it's paragraph 61 of his report. And he says, he begins by making the observation that the judges that have considered CFAs have not, it says, no reference has been made by the learned judges in cases considered above on any requirement to have a minimum sum in order for it to be considered a basic or fixed fee. However, it would be trite to state that the basic or fixed fee should not be a mere nominal sum, lest the fee arrangement will be viewed in its entirety as substantially being contingent in nature. I'm of the view that the quantum of basic fee to be agreed would depend on, inter alia, the quantum of claim, the fee percentage, the complexity of the case, and the anticipated quantum of success fee. In my view, a payment of 100 to 200 ringgit as a basic or fixed fee would be a nominal sum, considering that the filing fee of the case in the High Court is 400 ringgit. And he then goes on at paragraph 62 to say that he thinks, however, that a upfront sum of 500 to 1,000 ringgit would not be nominal and would therefore be lawful. The claimant's expert addressed this issue of what is and is not a nominal sum. If I can ask you to stay in the same volume and turn to tab 15, page 284, please. This is retired Chief Justice Richard Mallinger. Sorry, I think I've given you the wrong page number there. It's page 284, and the heading is Level of Basic Fee proposed by Dato Ma. Paragraph 134, Chief Justice Mallinger agrees a nominal basic fee would increase the risk of an agreement being struck down as unlawful. I agree with Dato Ma that in the hypothetical situation that the court found a basic fee structure to be lawful, the court would need to consider the quantum of claim, the fee percentage, the complexity of the case, and the quantum of success fee. And then over the page at paragraph 137, Chief Justice Mallingham says his view is that Dato Ma's suggestion of a basic fee of 1,000 to 1,500 ringgit would be an entirely nominal sum. It would be a facade to circumvent the prohibition on full CFAs. And you'll see that a very similar conclusion is reached by the claimant's other expert, Dato Malik, which is at tab 16, pages 324 to 343. Paragraph 151, Dato Malik makes the point a nominal basic fee would be a clear device to circumvent section 112, that's the prohibition on full CFAs. He notes that the cases don't make any pronouncement as to what would constitute a valid basic fee. But then in paragraph 153, he notes that these legal professional, LPPR, which is legal professional ethics rules, provide that in considering the amount of fees overall, various matters should be had regard to. And you'll see they include the time, labour and skill required, novelty and difficulty of the question, the amount in controversy. And at 154, page 343, he refers to Dato Ma's opinion that a basic fee of 1,000 ringgit would not be nominal, and he disagrees. He says it's disproportionately small when considered against the factors considered above. Now, before the judge, my lord, one of our arguments about the proposed arrangement was that if you look at the quantum of this case, it's very large compared to the proposed basic fee. So, in terms of quantum, the liquidated damages claim is around 1.5 million ringgit, about £250,000. So the proposed basic fee is less than 1,000th of that. And then in addition...
That's pleaded economic losses, is it?
It is. It's
liquidated damages.
Yes, that's right. That's right. And then there's the unliquidated damages for loss of liberty, personal injury, aggravated exemplary damages, and there's personal and proprietary remedies for unjust enrichment. And we submit that a basic fee of £167, which is £7 per claimant, is obviously at risk of being nominal if the value of the claim is relevant to that question of whether it's nominal. We also point to the complexity of the case. I've already taken you to the part of the judgment where the judge says this is going to take thousands of hours. And we made this argument for the judge and we said, look at the quantum, look at the complexity. There's at least a risk this is a nominal basic fee and therefore unlawful. And the judge doesn't engage with that argument in his reasoning on access to justice. His reasoning is at paragraph 167 of the judgment. And he makes 2 points. He refers to a 2005 case in the Malaysian courts, in the case of Chai Chi Chin, where there was a 1,000 ringgit upfront payment. And he refers to proposals by the Bar Council, some proposed rules which would involve a minimum requirement of 1,000 ringgit. Now, we say that he was wrong to reject our experts' evidence by reference to those 2 points. We say that the Chai Chi Chin case wasn't concerned with what is a nominal or non-nominal payment, and the Bar Council rules have not been adopted. They are not enforced, and that's because primary legislation at present prevents the Bar Council from even promulgating rules of that nature. But leaving aside that, what the judge doesn't do is engage with our argument that the fee that's proposed is nominal when considered by reference to the quantum of the claim and when considered by reference to the complexity. He just doesn't deal with it. And we say if he had dealt with it, he would logically have been bound to conclude there's at least a risk that it's nominal, therefore unlawful.
One of the undertakings given was by the defendants not to seek to challenge the lawfulness.
That's right.
Who else might it be susceptible to?
Well, I mean, I suppose one risk is the possibility of, there's the fear of disciplinary proceedings being brought on the basis of a complaint made by someone other than the defendant. But there's also a broader point of principle, which is that, and this is a point that's made by Mrs. Justice Lang in the AAA and Unilever case, you can't expect a claimant to resort to an unlawful funding arrangement or potentially unlawful funding arrangement, even if in fact they could do. So in that case, in Unilever, CFAs were unlawful in Kenya, but the evidence was that de facto CFAs were rife. And Mrs. Justice Lang essentially says that's not good enough. You can't expect claimants to, you can't say they've got access to justice if that requires them to engage in an arrangement that's potentially unlawful. So that's...
Your other point, presumably, is you can't expect the lawyers to agree to do it.
Well, yes, you can't
Even
expect
if the claimants would be willing to
yes,
engage them on that basis.
That's right. But the second argument under ground 2B is concerned precisely with, is it realistic to expect that a lawyer would be prepared to act in this case on the basis of the fee arrangement proposed by the defendants? The key passages in relation to this issue are paragraphs 139 to 143 of the judgment. And at 139, the judge says, I've taken you to part of this already, I agree with the proposition that if the claims proceeded in Malaysia, this would involve considerable financial risk for the claimant's legal representatives, who would have to commit thousands of hours of work and be at risk that they would not recover them. Also, they might be required to incur translation costs and potentially some forensic accounting costs to particularise the unjust enrichment claims. We say in brackets, and also the other costs that the judge has overlooked, which the defendants assume would be borne by the Malaysian lawyers. He then says they wouldn't have to set up remote hearings in Bangladesh and Nepal because those arrangements would be met by the Dyson defendants. The question for this court is whether, given the hours of work involved, which might not be remunerated at all, and the translation costs that might be required to be paid, there was a real risk that the claimants would not be able to find suitably qualified lawyers to take on their case. And he notes then, next paragraph, various witnesses expressed the view that this risk was real. And he summarises some of the evidence from Dato Malik and Mr. Ananth, who's another Malaysian lawyer. But then at paragraph 141, he notes that Dato Malik's view was countered by Mr. Chandrasekharan, who stated that his firm would be able to manage the claims and would bring in other lawyers to assist it, if necessary, or cooperate with other firms. He named 3 other lawyers who he said might be able to assist with the case. And then he goes on to summarise Mr. Chandrasekharan's evidence, which I'll take you to in a moment.
At whose request did Mr. Chandrasekharan give evidence?
The defendants. And I'm about to come to that, my lord. At 142, the judge says, I consider that the evidence of Mr. Chandrasekharan was cogent. And then he goes on at 143, I appreciate that this is evidence of one potential lawyer only, but that is sufficient, in my judgment, to mean that proper representation for the claimants can be achieved in Malaysia. So what you see is the judge, and I think my lord Master of the Rolls alluded to this earlier, the judge concludes the claimants can get legal representation on this basis in Malaysia because Mr. Chandrasekharan says that he would represent them. There's 5 key problems with that conclusion. The first is that the judge simply ignores the fact that, having given evidence as a witness for the defendants in this case, there is at least a very real risk that Mr. Chandrasekharan would be conflicted from representing the claimants in proceedings against the defendants concerning the very same subject matter as this case. You can see how that risk arises from this witness statement. I'll ask you to turn up the second statement, please, which is at tab 12, the SSB, page 227. Paragraph 4, he explains, this is his second statement, he explains how it's been prepared. This statement has been prepared with the assistance of the defendant's solicitors. A first draft was produced by the defendant's solicitors following a detailed interview with myself, conducted via Zoom. I worked with the defendant's solicitors to finalise the statement. Now, a couple of points in relation to that. It's clear from the content of the statement that Mr. Chandrasekharan has discussed with the defendant's solicitors how he would act on behalf of the claimants in this case. Now, we don't know the totality of those discussions because they're obviously legally privileged, and it's not Mr. Chandrasekharan's privilege to waive. But there must, in circumstances where he has discussed with the proposed defendant how he would act for the claimant in a proposed claim against them, there must be at least a risk that a professional conflict arises. But even if somehow there wasn't a professional issue, there's another important issue, which is that in order to have access to substantial justice in Malaysia, the claimants who are impoverished, vulnerable, outside the country, don't speak the language of lawyers, need to be able to have trust and confidence in the lawyer that represents them in Malaysia. And how, we rhetorically ask, can that be the case if the lawyer is someone who, A, has actually given evidence in support of the defendants against the claimants in these proceedings concerning the same
I'm not sure
subject.
this point needs a great deal of elaboration.
I'm grateful, Model. And B, I was going to say simply, if they ask him, what did you discuss with the defendants, he'll have to say, I can't tell you, it's a privilege.
I mean, was all that put to the judge?
My Lord, I'm not sure that that point, I can check whether the conflict point was put to him. I think it was. I'm not sure to what extent we unpacked it, and I can find out overnight, my Lord.
You had 5 key problems, you've only dealt with 2.
Yes. Well, the second one is that the judge's reasoning assumes that Mr. Chandrasekharan would be willing to represent the claimants under this arrangement involving an upfront fee of just 1,000 ringgit. But it's very striking that Mr. Chandrasekharan does not confirm this in his witness evidence. Can I ask you to look, please, at his first statement, which is behind tab 7, and the relevant page is page 120, paragraph 24. It starts on page 119. And what he's doing here is he's explaining how he would calculate the fee that he would charge the claimant. I would anticipate asking the claimant for an upfront payment. He goes on to say, the amount of upfront payment depends on many factors. There would be a balance to be struck between what the claimants could afford and the success fee. As I know nothing of the claimant's individual personal circumstances and have not been able to consider their cases in detail, I cannot at present say what I would charge, but I can say that I would be open to considering a higher than usual success fee in an effort to charge an upfront fee which was affordable to the claimants. So despite the defendants very clearly saying you will be able to get a lawyer who will act for you on the basis of an upfront fee of just 1,000 ringgit, the one lawyer who they point to as an example conspicuously does not say that that is a basis on which he would be prepared to act. He's at pains to say, I can't say what I would charge. And all he says, I'd be open to considering a higher success fee. Well, that's a very long way from providing a basis that enables the court to conclude that he's sure to act on this basis that's been proposed. The third problem with Mr. Chandrasekharan is that we adduced evidence from witnesses dealing with Mr. Chandrasekharan's representation of claimants in the case that's called the Goodyear case. You'll see there's reference in the judgment to the Goodyear case. And Mr. Chandrasekharan says this case is an example of how I was able to represent migrant workers effectively and obtain access to justice. But we adduced evidence from a Ms. Sridharan, who's a migrants' rights consultant who had some involvement in that case, about serious shortcomings in his representation, and in particular a failure to communicate effectively, regularly, and in a language that the clients could understand throughout that case. And I'll just give you the reference. I don't think we need to take time looking at it. Her witness statement is at SSB Volume 1, tab 20, in the relevant paragraphs, so paragraphs 32 to 39. Now, we relied on that evidence before the judge. The judge doesn't refer to it anywhere in his judgment. Now, in the defendant's skeleton argument before this court, they say the judge was right not to have regard to what they describe as ad hominem criticisms on Mr. Chandrasekharan. That's paragraph 54 of their appeal skeleton. But these are not it's not a gratuitous slur on Mr. Chandrasekharan. It's evidence showing real problems in how he communicates with migrant workers when he's representing them. And in that case, the migrant workers were in Malaysia. In our case, they're in 2 foreign countries. And so that evidence is relevant to his suitability to represent our clients, and the judge doesn't engage with it. My lord, the fourth point about this part of the judge's reasoning is that...
Fifth, I think.
Sorry, my lord?
This is the fifth.
I may have inadvertently split a point at some point,
Okay.
my lord.
Yeah, I had trust and confidence as point 2, but I think you wrapped it up in point
I think I did, but I'm happy for it to be split out for an additional point. The fourth is just concerning paragraph 142 of the judgment, which is where the judge explains why he is satisfied that Mr. Chandrasekharan's evidence addresses the concerns identified by Dato Malik. And
Yeah.
I can be quite quick about this.
Yes.
The judge says, just about 2/3 of the way down the paragraph, the key concern for Dato Malik was whether the success fee would be substantial enough for the various lawyers making up the overall legal team to share in. This was addressed by Mr. Chandrasekharan's evidence that he would charge a higher than usual success fee to take on the claimant's case, and there's nothing to suggest that the claimants would not agree to that. 2 problems. First, that wasn't Dato Malik's only concern. He sets out other concerns at paragraph 236 of his expert report, which is page 361 in the SSB. His concern is not only about sharing success fees, it's that if you have small firms that take on a huge case like this that's very resource intensive, that constricts the cash flow for the firm, and that can lead to lawyers either disengaging at some point because it's just not financially viable for them to carry on, or it can lead to pressure being put on clients to settle the case so the lawyers can get some cash in, or it can involve the lawyers taking on other work and not attending to it. So the judge doesn't engage at all with that aspect of Dato Malik's concern. But secondly, Mr. Chandrasekharan says, I'd be open to considering a higher success fee. And the judge says, well, there's nothing to suggest the claimants would not agree to that, but how could we agree to it? As this abstract proposition, we don't know what success fee he's proposing, we don't know what a higher success fee looks like. It wasn't incumbent upon us to respond to a hypothetical, non-specified success fee that Mr. Chandrasekharan is open to considering. So we say that's the fourth reason. And the fifth reason is that there was no evidence that any other firm of Malaysian lawyers would be prepared to represent the claimants on this basis. And it's notable that Mr. Chandrasekharan names 3 other firms in his witness statement who he says might be able to act on a case like this. He doesn't say anything about whether they would be prepared to act on it.
Did you put any evidence in about having sought Malaysian lawyers?
We had evidence from NGOs. I mean, our primary case concerned legality of these arrangements. We also had evidence from NGOs in Malaysia who talked about some of the difficulties they find in obtaining lawyers to act on these cases. We didn't have, in a sense, it's hard for us to prove a negative and have evidence saying there is no lawyer who would act on this basis, because the defendants have put forward this basis, and I'm just seeking to establish that actually the evidence they rely on in support of it simply doesn't do the job.
Yep.
And so, just to conclude ground 2B.
I'm just a bit worried about the time.
My lord, I'm just turning to ground 2C. I don't propose to address you on ground 2D, so this is the final ground. I think I have 10 minutes, and this is quite short. Ground 2C, this is addressed at paragraphs 54 to 55 of our appeal skeleton. Our submission is that the judge wrongly failed to have any regard to the fact that the claimant's inability to attend a trial in person in Malaysia presents a real risk of injustice, irrespective of whether there could be a remote hearing. Now, as I explained at the outset, it's common grounds that the claimants who are outside of Malaysia, which is the significant majority of them, would be unable to attend a trial in Malaysia, any hearing in Malaysia, because of, amongst other things, a fear of arrest, and there's evidence of fear of reprisals. And so before the judge, we submitted that the inability to attend a hearing in person itself meant that there was a real risk of injustice. And in support of that argument, we relied on the judgment of Mr. Justice Tomlinson in Alberta and Katanga Mining, which you'll find in the authorities volume tab 12. It may just be worth briefly turning that up. The judgment starts at 281. This was essentially a civil fraud case concerning a Congolese company. And if you turn to paragraph 35, you'll see that there is reference to fears for the personal safety of Mr. Buchan. He's the owner of the claimant, and he fears for his personal safety if he has to travel to the DRC for a hearing. That submission is developed at paragraphs 37 and 38 on page 309 in the bundle. And in response to that submission, Mr. Justice Tomlinson says this at page 310, paragraph 39. In any event, it is, I think, undesirable that a litigant should be denied the opportunity to attend the proceedings of the court in which his cause is being heard. It is equally undesirable that a litigant should feel under any inhibition about travelling to the country in which litigation on his behalf is being conducted, in order properly to brief and to consult his lawyers.
Yeah.
Yeah. And it goes on to talk about...
I mean, that was pre-COVID, of course.
Yes, it was, my lord. Now, we, in our High Court skeleton argument, we expressly relied on this authority in support of the proposition that our clients would face a denial of justice, even if they could participate by video. The judge refers to that argument.
I'm going to argument to make with this particular judge who thinks that the remote hearings work rather well.
I'm going to take on the
justice to litigants for years now.
I'm going to take on the challenge, my lord, and see if I succeed. The judge
on the basis of the proposition that it's undesirable.
It's undesirable. He goes on to say these considerations all tend to suggest that justice requires that Alberta should be.
Well, you know, you can't construe a first instance judgment in a completely different case in a completely different world as a deed.
My lord, of course.
This is really tinkering with the facts. I mean, you've got to get your screwdriver into the guts of this.
Well, my lord,
your conflicts arguments are arguments that I quite understand have that quality if they're right. But this is.
Well, my lord, can I just make this point? If you're with me on conflicts...
How are they going to come here anyway? I mean,
well, they can. My lord, we've got evidence about that, which I was about to come on to.
Visas and so on. I mean, I've been told in cases that people are coming from places like we're talking about, and all of a sudden they can't.
Well, my lord, the evidence of Mr. Holland expressly refers to this. So I'll just give you the reference. Holland 1, paragraph 124, Core Supplementary Bundle, tab 2, pages 54 to 55. He explains that Leaday will be able to help the claimants obtain visas to travel here, fund all necessary travel and accommodation costs. And this is something Leaday have done in other cases. And you get evidence about that in Holland 2, paragraph 172.1, Core Supplementary Bundle, tab 8, page 183. And there's just a couple of points I'd make in relation to this. This is a point we relied on, and the judge didn't have regard to it. So he
didn't mention it.
He didn't mention it. He mentions it in his summary of our arguments at paragraph 71, Roman numeral 5.
So why does he have to do more than that?
Well, my lord, because we submit it's an important point, and he ought to have engaged with it. And I'll just explain my final submission. There's 4 reasons why we say, actually, in this case, being unable to travel to the hearing actually does present substantive unfairness for our clients. First is the subject matter of these claims. These claims concern serious allegations about grave human rights violations. And one of the purposes of bringing a claim like this is not just to get financial compensation, it's to get vindication. That's a legitimate and important objective for clients in the position of the claimants. And we say that they have a legitimate interest, therefore, in attending the trial in person because of the vindicatory function that comes from being able to be present in the court, to be heard in the court, and to see justice be done in person. And it's particularly problematic if they can't attend a trial when the inability to attend the trial is a direct result of the wrongdoing that's the subject of the claim. So here they can't travel to Malaysia because they ended up working illegally in Malaysia because of the failures, the subject of the claim, or because they fear reprisals from those that they are making allegations about in Malaysia. Secondly, we submit there is a point about evidence, quality of evidence. The witnesses, the claimants will have to give evidence through translators. And everyone knows how difficult it is and what effect it's had on the intelligibility.
Everyone knows submissions are always rather
I say, my lord, I just submit that when you're dealing with evidence being given through translation,
it can be problematic.
It can be problematic when it's through a remote hearing as well. The fluency and impact of it, less impact. And then there's just two more points. As I said, these claims concern, in some cases, matters that are very traumatic to my clients. Now, if they were attending a hearing in person, then their legal representatives would be able to help, put with effectively the pastoral arrangements to support them through a traumatic process and thereby enable them to give the most effective evidence. That's not going to be the case if they have to take part thousands of miles away. And then fourthly, and this is my last submission, there's an equality of arms point. On the defendant's approach, all of their witnesses, all of their executives, all of their lawyers will be present in the courtroom throughout if they want to be. But none of the claimants will be present. And that's problematic generally, but it's particularly problematic here where there's already a vast disparity between the parties' resources. And so we do submit that actually this is actually a relevant factor in this case.
Suppose that, as has occurred in the past, visas were refused on the basis that there's a risk of absconding.
One possibility.
Commonplace. Would your clients not get substantial justice in this jurisdiction?
Well, there'd be alternatives. For example, the court could sit as a special examiner, as it has done in other jurisdictions. The Malaysian court can't do that, and we have evidence from the defendant's experts say that's not possible. But my lord, I have to accept that this is not as significant a point as grounds 2A and 2B, but we do say it's an important one. It should have been addressed, and we do say it inures in favour if the court appeal is effectively re-exercising the exercise. This is something that goes into the balance.
Your point is that the judge ought to have found there was a real risk overwhelmingly on the grounds of conflict.
Yes, that's certainly one of the main ones. Now, my lord, just in ground 2D, it's in our skeleton argument. I recognise realistically, if you're with me on the first three grounds, I don't need ground 2D. If you're not with me on the first three grounds, it's unlikely ground 2D will make a difference. So I simply rely on my written submissions in respect of that.
Thank you very much, Mr. Gibbon. Yes, yes. Mr. Gibson.
My lords.
We've got your 15 minutes this afternoon to poison our minds.
Yes. To enlighten you, my lord.
Sorry, I meant
yes, indeed. My lords, you have our skeleton, and I'll use that if I may, as a route map for my submissions on stage 1 and stage 2, starting, of course, with stage 1.
Are you allowing your juniors to make submissions already?
Possibly, my lord.
Well, it would be a very good thing, you know, that we urge all parties in the Court of Appeal to get their juniors to make part of the submissions to the court now.
Well, I'm grateful for that, Steer.
As the other side have done, commendably, if I may say so.
My lord...
It's a direction from the Lord Chief Justice, Lady Chief Justice.
Yes.
And me, amongst others.
My lords, I'll be referring to my skeleton and, of course, the judgment, if that could be readily available to you. That would be helpful.
The judgment?
And the judgment.
Not it.
What I'm going to do in the first instance is to go to the particulars of claim. It's highly material to stage 1, obviously, because the first question under stage 1 is what are the issues, and against the backdrop of the issues, the court decides whether the
What
case...
did the judge say the issues were?
He identified them in his judgment in paragraphs...
And do you say that's wrong?
No, that's right. Then there's no criticism.
Why do we need to do the job again? It's not been challenged.
Because I need to show the court, I think, why the centre of gravity of this case is so clearly, we respectfully submit, Malaysia. And the best place to show you that is by cantering through the particulars of claim.
Okay, can we look at what the judge said about the issues?
Yes, of course. If you go to the judgment at paragraphs 7 through to 13.
Yeah.
And I rely in part on the fact that there is no criticism of his recitation of the issues, and that in my submission is relevant to his appraisal of where the real and substantial connection of this case is.
Yeah.
And if one goes to the particulars of claim, which is core bundle divider 10, page 135, in my submission, it becomes immediately apparent why this is so clearly applying the Spiliada test, in shorthand, a Malaysian case. If you go to page 135, you note first of all that the claimants are 23 Nepali Bangladeshi migrant workers and the personal representative of the estate of one deceased Nepali migrant worker. So there's 24 claimants. And each of the 24 has exhibited to the generic pleading a schedule, and the schedules start at page 209 of the core bundle. And each of these claimants has scheduled what is called the summary of claimant-specific facts, which examine working conditions, accommodation, end of employment, underpayment, personal injuries, and other matters, leading to particularisation of damages at 213.
Is any of it disputed, that the first claimant is a male Nepalese national who worked at the factory facilities operated by ATA? I mean, is that contested? Is that the kind of fact that we're going to be contesting in this litigation?
His employment details will have to be obtained from ATA. I simply don't know to what extent the basic details will be contested, but the allegations, of course, of mistreatment will be.
But that's not an allegation of mistreatment.
No, I'm simply saying to my lord,
employed and working as a machine operator in the measurement department and blah blah blah.
well, these allegations, the point I'm making is that these allegations are very specific. They are very claimant specific. They're detailed, and they span for the period of this action a period of 11 years.
But I mean, the issue, I would have thought, the fundamental issue is whether the defendants have any liability for somebody who is employed by ATA.
That's an issue of law, certainly, my lord.
Sounds like quite a big issue.
It's a fundamental issue of law, and I don't. We would submit under Malaysian law, it is pushing at the boundaries. But what I'm seeking to justify at the moment is the judge essentially saying that these are contingent claims, which they are. They depend upon establishing the levels of mistreatment in the first instance.
Well, the level of mistreatment. Mistreatment is not enough. You need to show extreme mistreatment.
Well, you then need to show that the causes of action are made out, and as you've heard and seen, the claimants rely on negligence, unjust enrichment, and joint tortfeasorship.
Yes, but I mean, even assuming mistreatment, I imagine, I mean, obviously you don't assume it, but assuming it were the case, a lot of the argument is going to be, even if there were mistreatment, it's not a liability that falls on us, because we had codes of practice, we had codes of conduct, we took steps to make sure that those codes of conduct were implemented, and we did everything we could possibly do, so you can't sue us.
Well, indeed, my lord, that will be important, but key at this stage is identifying the nature of the issues that the trial will involve.
But these are people who live in Bengal or Nepal or somewhere else. They don't live in Malaysia now, and many of them can't even go there.
Yes, and they'll be giving evidence remotely.
Well, they, according to the claimants, if it's here, they'll be giving evidence in person. Well, you heard my slight suspicion.
Yes, that's another point, my lord. But if I could just,
okay.
I won't labour this. But
yeah, well, I mean, we've read all these, we've glanced at these pleadings and we know what the case is
Well,
about.
could I just highlight some key points in the light of the questions that were put about Dyson Malaysia?
Yeah.
To see, this is the case that we face in relation to Dyson Malaysia, and it's paragraph 7, you see it. Is the company incorporated and domiciled in Malaysia. The head office is located at Johor Bahru, approximately 1 kilometre from the factory premises. Its principal activities consist of the manufacturing, sale and distribution of Dyson products, management of contracting services, and the direct oversight of the relationship between the Dyson Group and the owners and management of the factory facilities, including in relation to issues concerning worker recruitment and conditions of work at the factory facilities. And then you see at paragraph 12, they rely on page 138, they rely on the various agreements that were entered into by Dyson Malaysia and ATAJ. And Dyson Malaysia is the only contracting party. You then have, this is the obviously, this is the way the claimant is structuring their pleading. They then set out in generic terms the working conditions, and you'll see the analysis of individual working conditions and economic losses alluded to in paragraph 16 at page 140, and then various allegations about the living conditions over the course of the 11 years follow. Then you get at paragraph 22 the allegations that 4 of the claimants are making, that they were detained, subjected to false imprisonment and beatings by the Malaysian police, for which the defendants are held liable or alleged to be liable. Then you, at page 148, paragraph C, they begin to set out the allegations that they broadly rely on to make out the duty, which I know your Lordship rightly says is a feature of this case, and I don't suggest otherwise. But they rely on the defendant's knowledge, and general assertions are made as to the defendant's knowledge. They then plead, over the course of a number of paragraphs, the various Dyson codes of conduct and various policies. There's no, as you can see, they're set out. There's no dispute about them. What matters is whether or not they were enforced in Malaysia.
Well, yes, that may be one thing that matters, yes.
But in my submission, that's the key thing. And then they plead at paragraph 58, and my learned friend took you to this very briefly. Well, first of all, they plead, and my learned friend did take you to this at page 160, the personnel who may be able to give evidence that is relevant to the issues of Dyson Technology Ltd and Dyson Limited. And I don't suggest that there will not be a role for them. But when you move to Dyson Malaysia at paragraph 58, you see why Mr. Holland, in fact, and I'll take you to it, says that Dyson Malaysia played a central role. They plead against Dyson Malaysia at 58.1 that it was responsible for setting the standards, that it was responsible for running a comprehensive program of regular audits, 58.1b, that it was responsible for setting standards, that it carried out audits, that it carried out training and implementation of policies, that it was responsible for setting worker welfare standards, and was responsible for supplier training. And then it identifies the various jobs fulfilled, or it's alleged would have been fulfilled or were fulfilled by Dyson Malaysia. And that culminates in paragraph 58.4 on page 168 with the allegation that Dyson Malaysia employed various employees who were specifically responsible for the creation management of the mandatory standards and policies concerning the working living conditions, who worked at the factory press facilities operated by the ATA companies, and for the implementation of those mandatory standards and policies throughout the Dyson Group's supply chain, including by auditing, training and prescription and enforcement of the remedial action.
Actually, how many employees did Dyson Malaysia have? You obviously know, since you represent them.
It's actually not in evidence,
Right.
but it's about 220 at the moment, as I understand
Right, okay. Thank you.
Sorry. I'm so sorry, 1,200. Then the claimants rely on various public documents in order to make out the knowledge, which is one of the ingredients they rely on to build their duty of care case. But again, they rely heavily, as you can tell from page 170, the heading, knowledge of the claimant's subjection to unlawful forced labour, on the defendant's audit and monitoring process, which is Dyson Malaysia, and so on. You then get to paragraph 64, 176 of the bundle, termination of the Dyson Group's relationship with the ATA companies and ATA IMS in November 2021. And that happened, and there was evidence to this effect, because Dyson were not satisfied that ATA-J were fixing readily fixable problems that had been identified.
These problems?
Not necessarily. There's certain problems that had been identified, and they were not, which were readily fixable. And
I thought we saw that they accepted that the evidence of all this came to light for the first time in 21. That was
yes.
your evidence.
The point that I'm making is that it wasn't a case of accepting that the allegations were all true that were being made about ATA-J. It was simply because ATA-J were not satisfying the Dyson Group that they were fixing the problems that had been identified, or some of the problems had been identified. Then you get applicable law, and of course there's no dispute that the applicable law is Malaysia. And in the light of what is said about unjust enrichment in the applicable law attack, you note at 65.2 that it's again alleged that Malaysia at 65.2b is the country where the unjust enrichment took place, and C, where the non-contractual obligation arising out of the unjust enrichment is manifestly more closely connected with Malaysia than any other country. Then you get all the provisions of Malaysian law that are relied on. These are all the employment-related provisions that stretch over a number of pages that ATA-J have failed to comply with, which the judge in my submission reasonably and sensibly said Malaysian judges would be more familiar with.
As a matter of public policy?
Yes, he does.
Do you accept, do you say that's right? That he should take into account public policy?
He doesn't take into account, in my respectful submission, public policy, my lord. Okay. All he's doing is applying Lord Mance and saying that it's preferable for Malaysian judges to deal with issues of Malaysian law that are novel and where there are material differences. He uses the word policy in order to say there are good policy reasons for that. But when you analyse his judgment, he is saying no more than the policy reasons that underpin what Lord Mance said. What Lord Hope and Lord Bingham are talking about in Connolly is a completely different argument that was being addressed to them, that the court should take into account public interest and public policy, as it were, extraneous from the Spiliada exercise. And as you will have seen from Lord Hope's judgment, he said, you must take into account matters, circumstances that are relevant to the private interests of the parties and the interests of justice. Questions of applicable law and it being preferable for an English judge to, for the local judge to determine the cases is a perfectly proper example of taking into account a matter that is in the interests of the parties and in the interests of justice.
Yeah. So
he was not making the mistake that Lord Bingham and Lord Hope were referring to in Connolly.
Right.
So then at page 184, one has the particulars of negligence, and I respectfully submit that they all focus on the failure to ensure the claimants in Malaysia were provided with appropriate accommodation, and that's obviously going to involve substantially Dyson Malaysia and what they did or did not do. And then you get, at paragraph 189, liability for false imprisonment, intimidation, assault and battery. And at paragraph 91, various particulars of false imprisonment, intimidation, assault and battery are made, and it's said that the defendants assisted the primary tortfeasors, who are Atta J, and the case is built on an allegation that there was such procurement and assistance of the primary tortfeasors that there is a joint liability. So that is a case we submit again that is rooted in Malaysia, because it concerns, as you can see from 92.6, engaging in concerted action with the Atta companies. And then unjust enrichment is pleaded over a number of subsequent paragraphs. And as you can see from the allegations of unjust enrichment, they again focus on the conditions, because what is said at paragraph 101, page 196, is that the defendant's enrichment at the expense of the claimants was unjust by reason of 1011, unconscionable exploitation of weakness, duress, undue influence, and failure of consideration to void an unenforceable, non-existent contract. So again, the unjust enrichment case focuses on the conditions and allegations in respect of those conditions in Malaysia. And then you come at 201 to loss and damage, and you can see from the individual particulars, an example at 213, that what is being claimed are either personal injuries, which happened in Malaysia, certainly substantially happened in Malaysia, or financial losses, which are underpayment of overtime wages, underpayment of holiday pay, underpayment of public holiday pay, deductions from wages, and so on. And then false imprisonment damages, the false imprisonment in police custody and false imprisonment at the factory facilities. And at paragraph 119, you see that so far as distress and personal injury are concerned, those allegations are also made, or claims are made for damages against the police as well. So, my lord...
Sorry to interrupt you, but can you just help me with the unjust enrichment? You've shown us paragraph 65 of it, under the proper law pleading, said the enrichment took place in Malaysia.
Yes.
Which seemed at first sight slightly surprising for the English defendants. And then if one looks at paragraph 94, to see what the enrichment is said to consist of, it is consistent with that, because the defendants have been enriched through the saving of expenditure they would otherwise have incurred by obtaining the components and products at a cost significantly below the true and fair value, and receipt of the benefit of valuable industrial and manufacturing services. But it then does go on under expense of the claimants, 95.2, to say the circumstances in which the defendants were enriched through the receipt of valuable components falls within the exception. And then when we get through to the remedies, paragraph 131 and 132, for example, it said that the defendants are liable to make restitution of the value of the valuable industrial and manufacturing services, and that they hold on constructive trust, alternative resulting trust, all products and monies that can be traced from the components. Now, as far as the English defendants are concerned, it's quite difficult to see how that isn't a plea of enrichment taking place in England.
There is an element of the enrichment cause of action which takes place in England, that part of the enrichment you've identified. My point is that the substance of the unjust enrichment is overwhelmingly Malaysian, because all other elements of the cause of action involve proof of what happened in Malaysia. And even the calculation of the monies allegedly by which the English defendants, or one of them, was enriched, the calculation of that starts with what was earned or not earned in Malaysia.
I mean, you say it's all based in Malaysia, what happened in Malaysia, even if the knock-on effects, which may lead to financial enrichment,
Yes.
have taken place outside Malaysia.
Yes, I mean, applying the Metal-Roshtov test, standing back, where in substance did this tort occur, we say Malaysia. And,
Okay, now we were going to finish at 4:15,
We were.
Mr. Gibson, and it's now 4:20.
I'm grateful and I apologise.
Yeah, it's fine. We will resume at 10:15 in the morning. Don't forget, I'm saying it to remind myself, because I need to be here too. So we'll start at 10:15, which hopefully will give us the time. And you've agreed amongst yourselves the time for reply, have you?
We did agree half an hour.
Half an hour for reply, and that'll be split up or whatever, but that will be all there will be. I'm afraid I will really genuinely have to finish promptly at about 10 or 5 to 4 latest. Good. Thank you very much. We'll see you tonight.